This Thursday morning, March 20th, and we're going to take a look at another bill that we received from the Senate, S-44, and we'll have Legislative Council join us to walk through this relatively short bill that probably has a lot of background to it. But Rick, thanks for being here.
Yeah, good morning. All right, Rick Sagel, Office of Legislative Counsel. Pulling up S-44 as passed by the Senate. As the chair said, it's a two-page bill, which is a nice change up for me. Most of my bills are 30 plus pages, so I appreciate this one. Mr. Chair, would you like to just walk through with some background, or just walk through first and then go through the background of it?
Either, whichever way works, but yeah, we definitely want to have a little bit of background.
Right.
Some of us were definitely here for when this passed originally, but
right. Okay, so I'll start kind of with a little bit of background. So this bill amends really one statute in Title 20, and the underlying statute, which is still law unless this bill were to pass, relates to two federal laws. And one federal law, 8 U.S.C. 1357, they're also known as 287G agreements. These are immigration agreements where the United States Attorney General's office can enter into these MOUs with law enforcement agencies around the country to execute ICE kind of powers that ICE normally has. So again, federal law allows the AG's office to do this, and there are various counties, some states have entered into these MOUs, and Vermont in, I think, 2017 passed this law which said to enter into one of these agreements, the governor, in consultation with the Vermont Attorney General, can only enter into them. So the governor must approve of it before these agreements are executed. The other 19 U.S.C. 1401I, and I'll show you some information about these two laws here in a second. These are customs enforcement. So again, the United States can deputize local law enforcement as long as they've been trained to carry out these normally ICE specific duties when it comes to customs enforcement for 1401 or 1357G, regular law enforcement duties through ICE. Questions so far about those agreements? Okay. I believe Vermont's the only state that requires the governor's approval. I don't know how many other states have any agreements that require the governor to approve of them before they are actually entered into. So again, under current this bill does not change that. This bill still requires the governor to approve of these agreements before they can be entered into. However, current law says that if there is some kind of state or national emergency, local law enforcement can kind of circumvent this requirement that the governor sign off on these agreements. And I don't know the history of why that exception was included. My guess was there may have been testimony back in 2017 that said we need this exception to be more flexible. And this time, the thinking is it's fairly broad. It just says, I know it's crossed out, but a declaration of a state or national emergency is pretty broad. It doesn't specify which kind of state or national emergency. So the bill would strike out that exception and kind of add some clarifying language, which says no public agency, as that term is defined in 1 VSA 317. I can pull it up, but basically every municipality, state, county, board, local agency you can think of, or an officer, employee, agent, or independent contractor of a public agency shall enter into one of these agreements unless the governor has authorized the agreement as set forth in that previous subsection and the act takes effect on passage. So a little bit more information, then I'll open it up. The introduced version of this bill was much more deferential to the General Assembly, where the General Assembly would have to approve of the agreement in addition to the governor. So the governor would be part of it, then the assembly would have to kind of confirm the governor's approval. The committee decided that was maybe not necessary, and just to make this relatively small change, removing the exception in state or national emergencies.
Questions?
Yes. What facilitated this? Do you know?
Probably beyond the scope of what I can tell you.
So remind me that individual law enforcement officers can still choose to help ICE. It's a matter of whether there's an agreement. Isn't that correct? And municipalities can actually go ahead and, well, there's a question whether municipalities can go ahead and instruct their law enforcement to not cooperate. But even there, if an individual officer does, that complies with the US code, right? Is that, am I remembering that right?
So this bill is specific to these two agreements. Let me just quickly, while I have, this is from the ICE website. There's three models that this federal law applies to. And this 287G is not just an officer, being told to assist with ICE for detainment or some other purpose. These are the officers must be trained by ICE. They must receive certain training to be able to carry out what ICE normally does. So the bill just applies to these kind of major agreements between ICE and counties, cities, towns, states. So no, it would not affect a local law enforcement agency from doing these kind of informal tasks that assist ICE with detainment or stopping somebody.
Right, because I understand in New Orleans and Franklin County that sheriffs are occasionally, and you probably know that better than I do.
I work it.
What's that?
I work it.
Yeah, so, and is that right? I mean, that sometimes they're called to assist ICE and
Not usually,
not usually they have enough of their own people. Okay, all right,
it's
interesting.
supplemental.
Supplement, right? I guess the other question I had was, if there's a community like Steve has so-called sanctuary city, this doesn't impact what that community might be doing. Is that correct?
So, and this kind of came up in the Senate committee. You have, yes, various towns, not just in Vermont, but other states have these kind of sanctuary locations. Even the federal government normally indicated certain places were sanctuaries, hospitals, and a few other. So at some point, you're going to have preemption where if a federal executive order or something from the federal government says that this is no longer a sanctuary city, ICE can go into a hospital, ICE can go into a church. So this is not going to affect it, nor could it affect it. We have to remember that, Vermont as a state has certain limitations when it comes to how it can direct ICE. So I think this is one of the ways the state decided it could by having the governor be a check, this authority of local law enforcement agencies and towns and counties. So again, answer your question, this bill would not affect that, and nor could any bill really affect that.
Right.
Yeah.
Okay. Other questions? Yeah, probably. Barbara, then Ian.
So I had just heard a story in terms of on Long Island, there are some police forces where people are law enforcement is becoming part of Homeland Security staff in order to be assisting. This would mean that couldn't happen here unless the governor approved it. Is that right?
So I can't speak to what Long Island is doing, and I don't know. And this is the Department of Homeland Security would not necessarily be covered by these 287G agreements, kind of outside the scope of what I've researched here. This is really specific to ICE and the powers they have.
Okay.
And as far as these agreements, again, there could be these informal things that happen between the feds and local law enforcement. These are MOUs that are, and I can show you, you can pull up, these are public information. You can pull up, in fact, there's a map here showing you which states have these agreements. The white states don't have any. So you see Vermont there, and Maine, New York has at least one active agreement.
Right.
So, and they're pretty similar. They're pretty much copy and paste boilerplate, like this is what you can do. But I don't know as to that, what that arrangement is.
Ian.
Two questions. One, was subsection B of 4652 ever used from 2017 till now?
I don't know. I don't believe so, but I can't answer that question. I can get back to you on that.
And then, and I don't know if you answered this other question either. So I understand the MOU versus sort of an informal sort of understanding
Mhm.
legally, but like on the ground, what is the distinction?
On the ground by meaning actually what's happening in practice.
Yeah.
I mean, so when you have these, so the federal law is silent. Okay, so the federal law says the U.S. Attorney General's office can enter into these agreements with various local law enforcement agencies.
Yeah.
And it has to be a law enforcement agency. Okay, so Vermont decided in 2017, like, yeah, we recognize this is federal law. We can't change that. However, we want to add in this check that the governor's office, after consulting with the Vermont AG, must approve of it before this local law enforcement can enter into it. So in practice, what these mean is it's going to depend on the local law enforcement. They must get trained. And at that point, once they've been deputized, it probably varies based on what a county needs. If they need more support, less support. You have these three models: the jail enforcement model, the task force model, and the warrant service officer model. These are three different types of agreements. You can enter into all three or just one. So they are fairly tailored to what the law enforcement agency in that county or town needs.
So if there was a law enforcement officer who was operating informally with ICE, there's no MOU in effect, and there was some sort of like liability that happened, would they be covered by like the municipality that they work for, or are they outside of the umbrella of that work because there's no MOU?
So an officer that is informally, like without his or her supervisor knowing that he or she's doing this.
Well, I guess it hasn't really been made clear to me I was using the language that we've been talking about, like when you say that there's like they're sort of working together, but there's no.
Right.
Yeah.
I imagine there's some kind of, I say informal, meaning there's not an agreement, right?
Yeah.
Signed, but there could be some, we need assistance from local law enforcement to help us out with this specific task. And your question is whether something happens during this task that creates liability. That's probably something I would need to get back to you on. But it varies, right, based on what has happened. Did the suspect were their civil rights violated? Like, were they injured?
And I'm not trying to get into the weeds too much. I'm just trying to understand the difference between operating with an agreement in effect and operating without one. Like, is there protection there? Like,
I think these agreements are formalized and again require certain training, and you get more authority.
Yeah.
The local law enforcement have more right. And I want to make this clear. Like you do have authority. ICE is not going to ask, well, let me be careful here. You're not going to have these specific models informally given to a local law enforcement. I'll make that clear. Yeah. But like the chair said, if it's about a detainment of somebody that they suspect is not a U.S. citizen or is not here with proper documents, that would not be one of these models. That's just a detainment that an officer is maybe following orders from their head. So I hope that answers.
No, that helps a lot. Thank you.
Yeah.
For questions? Okay, we're good. Thank you very much.
Yeah, you're welcome. I'll hang around for a little bit.
Yeah, great.
Yeah.
We'll have Felco join us. Thanks for being here, Felco.
Thank you.
Oh,
yeah. Sorry about that.
no.
Right. So, whoa.
See if you could take the thing off the or stop sharing. Yep. No, that's fine.
So, good morning. For the record, my name is Falco Schilling, and I'm the Advocacy Director for the ACLU of Vermont. And I really appreciate the opportunity to come and testify to you today on S44. Just to start off, I want to say that we support S44 and the changes to the underlying statute that were made in the Senate. What I plan to do today is do a little bit of background on the underlying law, some of the changes that were made, as well as some other proposed changes that we are hoping could see be made in this bill to that underlying statute from 2017 to address some of the situations we've seen arising in the past couple months, and how we can think about better protecting Vermonters, similar to what we did with things like the SHIELD law, in terms of protected activity that is lawful under the state, or making sure that we're prioritizing the use of state resources in a way that focuses on our priorities. So just a little bit of background. As you heard, in 2017, the state of Vermont passed Act 5, which puts limitations on personal information that can be shared with federal authorities, specifically for the purposes of creating a registry. Registry is not fully defined in the underlying statute, but in looking at that language and from some of the context of the time, it seems pretty clear that one of the intentions of the underlying statute was to ensure that the state was not supporting efforts to create things like a Muslim registry. This was one of the first bills passed at the beginning of the first Trump administration. It was, signed by Governor Scott and kind of trumpeted as a piece of the work that we can do here in Vermont to ensure that we're protecting folks within the state to the greatest extent possible, especially when they're exercising their constitutional rights. Freedom to exercise religion was one of the main concerns under the First Amendment in that bill as passed originally. And then also contained within the bill was the prohibition on entering into these collaborative agreements without first getting approval from the governor's office in consultation with the attorney general's office. Something that we think is a good piece of law, in part for the reasons we discussed in this committee when we did things like barring the arrests, ICE arrests at courthouses, because there's a real concern that when local law enforcement are either perceived to be or actively collaborating with immigration enforcement, that immigrant communities might not take advantage of opportunities to cooperate with law enforcement if they are either the victim of a crime or they might be a witness to a crime. And we want people to be able to fully participate within the society and to have, that degree of trust with their law enforcement that are serving those communities. And I think that was one of the underlying goals of that statute, was to say, we're not going to be entering into these agreements in any unknown fashion. There are checks and balances, and it's something that would have to be known. And an individual department is not going to be striking out on their own, creating these type of collaborative agreements. And I think another piece of background, just to kind of flesh out the picture around the laws on the books and policies on the books that limit local law enforcement from participating in immigration enforcement, is also the fair and impartial policing policy, which is something that is mandated by statute, came out of this committee a few years ago. And then that policy has been crafted by the Criminal Justice Council in consultation with stakeholders. And the mechanism for that is that all state and local law enforcement is required to adopt at least the model policy that has been put forward by the Criminal Justice Training Council, which has a number of different ways in which that limits interactions with law enforcement, up to saying that they cannot communicate about immigration status. And that's something you'll see in the underlying bill. There's concerns about federal law, folks refer to as Section 1373, which prohibits any state or locality from explicitly prohibiting communication about immigration status. This is something that some states have struck out and said, we are in essence going to be scofflaws and say, I understand that federal law exists. We are not going to follow it. And we're going to see what the consequences are. Generally, under the first Trump administration, the consequences were withholding of certain grants, specifically for law enforcement. There's been a lot of litigation around whether or not that was a lawful withholding of funds. And there's a circuit split on that, where you have some other circuits saying that that was too attenuated. Those funds were too attenuated from the underlying statute. The Second Circuit, where we sit, did not have as much of a problem with that. And so I think one thing I want to say about my whole underlying testimony, as well as the existing model policy from the Criminal Justice Council for fair and impartial policing, none of these are running afoul of federal law, because they do not prohibit that type of communication about immigration status. And so, I think that in terms of some of the questions you had on what are the limitations on local law enforcement when if they want to collaborate with immigration enforcement, a lot of that is not in statute. That's actually in the model policy that was created by the Criminal Justice Council. And I think it might be worth the committee's time to get a little bit deeper dive if you want to know about what some of those limitations are. That involves things like shared use of facilities, when law enforcement would be calling federal officials for a roadside stop. It focuses on exigent circumstances, situations where it might be an emergency situation. So it goes through a number of different pretty in-depth scenarios that put limitations on that type of interaction. Though this committee passed and this body passed language a few years ago, I believe it was in 2018, which said that the Criminal Justice Council model policy should be the floor, but that municipalities could put in more restrictions on communications above and beyond that. And that was their prerogative, but was not going to be the prerogative of the state to require anything above and beyond adoption of that model policy. And in terms of enforcement mechanisms, folks have to, municipalities and the state have to have policies in place, or they lose the ability to get the services of the Criminal Justice Council, which can be pretty essential in terms of training and other supports. So that's a little bit of the background there in terms of some of the guardrails that exist outside of this piece of legislation.
So that was my question about Winooski, that they went further than the model policy, I believe.
Yeah.
And this bill right now doesn't affect that at all.
This bill would not affect that. So, and I guess to get to the underlying bill before I discuss a little bit more of what we are hoping, additions we're hoping to see to this bill, which we think are in line with the original intent. What the Senate did was to remove what we consider a loophole that exists that basically erase the checks and balances in the underlying law in a situation where there's either a state or a federal emergency declared. And as we were looking at this statute coming into the session, in November, we were doing our work trying to think about what can, as the ACLU, what can we put on the books that can help better protect Vermonters? And immediately, this Section B was something that was of concern because we anticipated, and as we've seen, the president is very willing and already has declared multiple states of emergency, one of which directly relates to the southern border. And the bar in terms of law enforcement agencies no longer having to get that check from the governor, being able to operate on their own and enter these agreements, is solely that, let me find the language, that the state of emergency, that they can enter those agreements when it's necessary to address threats to the public safety or welfare of Vermont residents arising out of a declaration of the state or national emergency. So that's a pretty broad standard. It has not been defined. That's something if a law enforcement agency were to enter into that agreement under the current state of emergency would have to be litigated in terms of what actually constitutes something that directly affects the welfare of the citizens of the state of the public safety and welfare of Vermont residents arising out of that declaration. I think looking at the plain language of the emergency declaration at this point in time, I don't think it comes to a situation where this section should come into effect. But at the same time, I don't know that other people might not see that as an invitation or read that statute differently and feel that since there's an emergency declared at the southern border, that also encompasses the work that's being done at the northern border. So at a high level, we fully support this language, which just keeps the authority with the governor. It keeps the authority to determine whether it's appropriate to enter these agreements with the governor and centralizes that power, and also then provides a greater level of transparency where that's going to be something that could easily be found out if the governor's entering to those agreements, and ability to have checks and balances, and they're going to have to collaborate with the Attorney General's office to decide that that is appropriate. So in terms of the underlying bill, we think that's a change that makes a lot of sense in terms of the original intent and also to meet the moment that we are in right now.
So maybe this is a question actually, maybe not so much for you, but for Rick actually. So Just looking at this again, why do we need the extra language in subdivision subsection B? Why isn't it sufficient just to strike subsection B?
So again, Rick Sable, legal counsel, this was also discussed in committee, Mr. Chair, and that was a concern that actually it was making things maybe slightly more confusing. Since subsection A makes it fairly clear that only the governor. I think the concern of that committee was, what if you have some kind of interim agreement or something that a local law enforcement agency does that is maybe they think that subsection A is not clear enough and they consider something to be an emergency. And they act on A without being told explicitly that only the governor can authorize the agreement.
There's no emergency language in A though.
Right. But a local law enforcement could say, so there's no language anymore, right, that says yes or no. We think this is a national emergency and therefore we're gonna do this
Right,
on an interim basis, maybe.
right, okay. Yeah, I mean, it may have made more sense to actually say that no public agency, including if there's a state or declaration of state or national emergency, but I see what you're saying. I mean, in the event,
Would the interim basis would that even be addressed in the proposed language for B?
So I think the purpose of B is saying that no agreement. The word interim is not used, you're right. I think the point is that no agreement in any form can be executed unless the governor has authorized it. And it could be that B is read as not making it more clear, maybe it made things less clear. That's something for you all to talk about and see what you think.
What do you think, Falco?
It's one, I think I could see arguments both ways. When we were talking with folks prior to the session, our suggestion was to cut B just in its entirety. But I can also understand some of the concerns that were raised in terms of trying to create greater clarity about the intent and what that means. They did in this change, they tried to make it explicit that it's not just law enforcement agencies that would need the governor's approval to enter into these agreements. But if you look at the existing A, I think the fact that only the governor can enter into these agreements might also cover that. So it's one of these things. I understand what the committee was trying to do. I think you could achieve it by multiple means.
Okay.
So I think we don't have a concern with the changes the Senate made, but also striking it, I think, could also accomplish similar purposes.
Okay, all right. So, Barbara.
And mine's on a different topic, so I don't know if you.
Yeah, no, I go ahead.
Okay,
No,
so I'm wondering from some of the other work that we've done, like things that already we have agreements, or not we, but maybe departments are sharing information with the feds, not related to this, but it would provide information inadvertently. Like I'm thinking of DMV. Because I know there have been issues in the past about information being shared. And I remember a bunch of years ago, law enforcement, if they got certain equipment, maybe it was the license plate readers, that they were required to, like part of the deal was giving information. And I'm just wondering if you've had concerns about anything like that.
Yes, and I think that's a really good segue to the next piece of my testimony and some of our proposed language. But I'm happy to hold off while there's more questions.
Yeah, before you segue,
I understand what you're saying, but I also want to remind everybody, they share a lot of information with us regarding criminal activity that is necessary to have.
Yeah, I know. You can't have a one-way thing.
No, and I'll tell you why in a little bit.
all right, segue.
So, building off of that and building off of some of those concerns, our proposal is to expand the prohibition on information sharing that exists in 20 VSA 4651B, which is the underlying statute relating to collection about religious practice and personal identifiable information for the purpose of creating a registry. Our suggestion is that we expand that section and put further prohibitions on what information state agencies are sharing with the federal government. But we also within here have language regarding an assessment procedure that could happen within the executive to identify whether the sharing of that information is necessary to comply with federal law. So in terms of the further prohibitions that we would like to see, specifically, we have concerns about the targeting of certain groups of folks moving forward under this administration. Specifically, folks accessing what we've defined under state law as legally protected healthcare activities. That includes getting abortion care, that includes any other sort of reproductive health care, as well as receiving gender affirming care. And as I look at my actual proposed language in 4A here, and in talking with folks like the Attorney General's office, there could be an opportunity to incorporate what we have done already within the SHIELD laws by reference, since I think that covers what we're trying to get at here. But this would be a way to consolidate within the statute and make it clear this is the type of information we do not want state agencies sharing. And there's been a lot of really good work done on that. And so we're trying to build off of that work and to bring into some other categories for folks that we are concerned about federal overreach. The next category of information we'd like to restrict in terms of sharing with the federal government or hostile states is when there is an investigation, attempt at prosecution, or attempt to impose sanctions to impose criminal or civil liability upon a person based on their participation in activities protected by the First Amendment of the United States Constitution. And this is something that is a growing concern for us at this point in time. When I testified in the Senate a few weeks ago, the immediate concern was you had top advisors and officials within the administration calling for DOJ investigations of members of Congress for simply providing know your rights information, for letting their constituents know about the state of the law, and insinuating that that is something that you could be seeing, federal investigations and prosecutions for just relaying information about citizens' rights, and especially with their interactions with ICE. Since then, this has become an even greater concern, where you have seen the administration actively targeting specifically college students for exercising their First Amendment right to protest based on the viewpoints that they are sharing, and the shown willingness to, in our view, illegally seize individuals based solely on the exercising of their First Amendment rights, and an indication that colleges and universities should be quashing protected First Amendment activity based on the viewpoint that it expresses. So,
I have a question.
Yeah, go ahead.
And I know you're on a roll, so I hate to interject.
Happy to talk.
I assume that you're talking about what's happening at Columbia as an example of this.
Yes, that's a very good example.
Yeah. So, I mean, the individual who was detained, I mean, he was aiding and abetting, and essentially was a terrorist sympathizer with Hamas. So I just think we want to be kind of careful, because I'm all for protecting Vermont citizens and making sure that we set up those guardrails and, however, when that extends into potential terrorist sympathizers and terrorist organizations, I think we just want to be really careful, because the testimony that I'm hearing right now, and this isn't a question, so I'm kind of going outside the bounds here, but I'll acknowledge that. But I'm happy to acknowledge that, is that I just want to be really careful, because what you're testifying, taken both in this room and then obviously people that are going to be watching this and hearing about this, could be taken as supporting a terrorist organization that is operating on U.S. soil.
What we're supporting is the right to exercise
And I'm
free speech
all
under,
for the
and
free
I would
speech.
disagree with the characterization that he's a terrorist sympathizer. And that's also our concern here. Who gets labeled a terrorist and where does that, what does that do to erode their due process rights?
Hold on a second. You also had a doctor in Providence, Rhode Island that was denied entry back into the United States despite being a visa holder because she attended the funeral of the Hamas leader. So, I mean, the thing that we're seeing at the federal level is not only protecting US citizens, but and also making sure that people have their First Amendment rights protected. I'm obviously very much for that. However, we have to be mindful that does First Amendment extend to non-citizens? Are we going to enable people that could potentially cause harm to US citizens that are here either illegally or via visa and are operating on the behalf of terror cells in the United States and foreign actors? So I just think we're going down a very, I mean, listen, I understand what you're here to testify about. I totally appreciate the importance of the First Amendment. I said, but as far as it goes to protecting potential terrorists, I think all of us would agree that is not what this bill should try to accomplish here.
So the question there is who gets to determine who's a terrorist? If we are disappearing people based off their viewpoints they have expressed in public protest without due process, that is a grave concern to all of us. That is one of the most slippery slopes we could address within this country. And I think that is why we're here today. The exact situations you're discussing. You're talking about someone attending a funeral. That's free association. That's free association. That's protected under the First Amendment. The fact that someone should have the right to say, we support certain activities that may be abhorrent to the beliefs we hold here. But the fact that we're then going to aid in the disappearing of these folks?
They did not disappear. I'm sorry to correct you. They did not disappear.
We are in active litigation on this.
So they are detained, but they did not.
Without due process rights.
They did not disappear. And let's just keep it even keel. All right.
Let's not argue on that. I mean, so.
But Martin, I mean, like, with all due respect, I cannot sit here in good conscience and listen to anyone defend terrorists on US soil. That's just like, I think that is one of the most ludicrous and insane things I've heard in this room, and that's a high bar. That is totally out of bounds.
So
inappropriate.
Understood where you're coming from, and I also understand the concept of who gets to decide who's a terrorist, and there's, I mean, First Amendment jurisprudence. I mean, you have to go a long ways before your content can be regulated or dealt with, and it has to be, you know, I'm talking about the real threat doctrine?
True threat doctrine.
True threat doctrine, and how that's going to play out with those two other situations, it seems, well, we'll find out. It's in the court right now. Yeah, we'll find out in court. So that's right. So yeah, go Tom. Yeah.
One thing to remind people, this obviously has a lot to do with ICE. And in my mind, one of the first pieces of reasonable suspicion of somebody doing something further is crossing the border deceptively. Deceptively.
Sure, right. Okay. So I think
That's
that
not
this
free speech issue or anything else. That's crime.
right. I understand that, and I don't think that this new language that Falco's talking about goes to that. And I would extend it beyond just immigrants. I would extend it to individuals who are transgender or non-binary, and how their First Amendment rights are in jeopardy in a lot of states. So
deal with those.
yeah, I don't know. I mean, so let's keep on hearing about this, Bill, in this language. And Ian, but yeah.
Well, no, I just think that one of the reasons why we don't testify when we're hearing witness testimony is that I don't want to be put in a position where I have to fucking address. Jesus. I feel frustrated by this, and I don't want to totally derail this conversation around testimony that we're receiving on this proposed legislation to try to address all of these huge issues, which is why I think we need to keep the questioning and the discussion to questioning of witnesses. So I just feel frustrated by that.
No, so let's do that, and we'll continue to hear continue to walk through your proposed language. And just a quick question though about that is, was this brought up with the Senate, and where was the Senate with this? Did they consider it fully? Did they run out of time? It seems to me that this came late in the session.
Well, I can't fully characterize the position of the Senate, but in conversations I had with folks, one of the major concerns was making sure that the language that they passed made it out before the crossover deadline. And as you see here, I think this does create a larger discussion. And they were concerned in terms of digging in more fully on this, that might make it harder to actually keep this bill moving. And so it was not, raised and voted down or anything along those lines. My understanding, there's an openness to continue this conversation.
Okay, Tom.
Wasn't the original language having to do with the legislature being able to make these decisions instead of the government?
Yes. Yep. And that was, sorry.
And this is additional proposed language that they didn't get to. But go ahead, Rick.
So it was, just want to make sure, it was still the governor, but then the assembly would have the up or down on that request.
Right. Which I don't see how that would have been, frankly. So, but that's fine. That's not what we have here, and I don't think we're going to change that language. But well, go ahead. Yeah.
Can I ask a question? This bill here that you're testifying on, what's this doing to protect my First Amendment rights, my children's First Amendment rights, my 4 granddaughters' First Amendment rights? What's it doing? It's protecting everybody else, but nothing with me. Does your organization not care about my family?
If I may answer, I care deeply about your First Amendment rights, and that's exactly what this is trying to do. When this talks about the lack of communication for prosecution of protected First Amendment activity, that covers everyone. This doesn't just include folks who might have different immigration statuses. And in particular, I think the greatest concern is of US citizens. And so this bill in itself would try and help protect the First Amendment rights of everyone in this country. And also, I think, to bring the heat down a little bit, within our proposed language in the next section, in terms of assessment by the executive branch, there is language allowing them to make assessments around whether that activity should be protected and whether it's within the state's best interest to provide that information. So just to your hypothetical, how is this protecting your First Amendment activities?
It's not hypothetical. I'm asking you a question. It's not at all hypothetical.
The hypothetical is, how might this language protect you, right? Is that is that what you're asking?
Sure.
Say in the future, we can take this out of this administration, any future administration. You are out protesting because you are upset about something that has happened, that you say, I cannot stand this. It is prohibiting the government, an outside entity, either federal governments or other states, from obtaining information from our state government that might prosecute you based on the viewpoint of the speech that you are offering. So, say there's a future administration that you are very upset with, and you have been very vocal about what they're doing wrong. You have the full right to protest that and to provide that speech. And this would prohibit them from the state from using our resources to support any sort of prosecution based on this. This applies to everyone within the state of Vermont who's trying to lawfully exercise their First Amendment rights. So it's a broad statement. And I think one of the concerns here is when we see the erosion of First Amendment rights for anyone, it leads to a greater erosion of First Amendment rights for all of us. This is why we have concerns around a wide range of activities that would look to regulate things under the First Amendment. Things that we find abhorrent, there's a line that we cannot cross, because as soon as we cross that line to regulate one viewpoint of speech, it's a lot easier to cross it to regulate other viewpoints of speech. That's why we can't regulate speech based on what we think is appropriate or our political stances.
That line has been being crossed for years, number one. Number two, you're focusing, or I believe, you're focusing on one administration. Forget about the past administration. They just let everybody come over the borders, whoever they want, whether it was south or north. We know we have a huge problem coming in from the north that is violating my rights, public safety can't control them. Nobody control, we're just letting them coming in. And it's
You have a
like,
question in there?
can I finish?
Yeah.
Thank you. So like, what are we going to do about protecting that? Because that's really what this is about, isn't it? It's about the border, right? That we've been dealing with. So how are we gonna do better on protecting the people that are already here legally?
I think that's exactly what I'm trying to, the language we're talking about here in terms of First Amendment protections, that's exactly what it's aimed at. The language around making sure that Vermonters can access healthcare without fear of retribution from folks in other states, that's exactly what it is trying to do here. And then in terms of immigration enforcement, all this is saying is that the state of Vermont has limited resources. I think that's something that we can all agree to, and that we should not be using those limited resources to be aiding in federal immigration enforcement. They have plenty of resources. They have the ability, and they are engaging in enforcement right now in a number of ways. This is just prioritizing how we use our state resources and saying this is not what we are planning on doing. It is not stopping anyone from doing anything. It is not violating any federal law. This is what we do all the time as a state. We decide how we want to use our resources, how we want to prioritize them. And so that's all we're saying within this bill. This is how we should prioritize it. And it still leaves the check with the governor's office around what information would be appropriate to share with federal officials. And that's our proposal.
So and before, just really quick, okay, so you don't have the language that Falco's talking about right now. It's online. His testimony, including this language, is online. But it's quite separate from what we're seeing here. It's not, I wouldn't say entirely separate because it's in the same subchapter or chapter of the law. But so I think we need to actually see this language and yeah, Tom.
Can I finish?
Oh, yeah, no, I'm sorry. Yeah,
You can let him finish. I just got one more thing.
So I got interrupted again on my last question for him because nobody wants to hear the questions that we want to answer. In my mind, I'm just trying, just a second. I'm done. I'm so done.
All right, go ahead. But I'm just trying to
You
make
may
it.
interrupt him a lot.
Well, I'm just trying to.
So done.
Well, I'm just trying to get you to understand there's different language than right here. That's all.
And there's different viewpoints. And you guys want to keep going and drilling this and drilling this and drilling this. We've already have all this
I
stuff
apologize. I was
in place.
Please sit down because I was trying to straighten out where we were, Ken. All right, fair enough. I was just trying to let's just take a breath. I apologize. I was really just trying to get Ken focused on that there's language about the First Amendment, which is not what's in front of us. That's all. That's all I was trying to do to get us to focus on that.
If you wanted to interrupt somebody, Falco should have been interrupted when he was showing an awful lot of anger
Right.
toward one of our members, which is very disrespectful, and nothing was done about it, and he was allowed to continue. When the member that was speaking to him was speaking in a very level tone, being very respectful, stating his opinion, stating the facts that he knew, and the witness was out of line.
I apologize for not having Falco, not calling him on that. I
And
should
you
have done
still
that.
haven't.
Well, yeah. Well, I've tried to get it moving over away from that argument is what I tried to do. You know, I tried to get it back to just let's talk about the language and have questions. That's what I was trying to do, to get away from that. If it went down that road again, I was going to, have to just call a recess. But didn't have to, I didn't think we had to do that. But obviously, so with all that, I think we will adjourn for now. We'll take this up later when we actually have language in front of us, and have language that we've had a chance to look at. But before we do that, Tom, if you had a question, you did have your hand raised it before.
I want to say, sort of in relationship to poker, I understand what Falco's trying to do. But I think a lot of people don't understand as well what law enforcement's trying to do. I already have the Fair and Impartial Policing Act that I have to follow when I work. I mean, clearly this is about ICE and all that, and it is almost impossible to do anything to even associate yourself with a Border Patrol agent as long as that Fair and Impartial Policing Act is there. It's a tap dance. And you have to be a very skilled law enforcement officer not to violate. It's not easy. And it's already caused a little bit of angst amongst the federal agency that works our border that my county relies upon because we don't have enough police officers. They respond to domestic assaults in Richford and burglaries that are active in Berkshire or whatever. We need them and we need to get along. And if there's more restrictions coming down on us that we can't help them, it's going to be like, okay, we're still going to be friends and work together, but we're going to be less likely to just jump out and help. And a prime example of that, when Chris Malin got shot, there was a Newport Police Department officer and a state trooper there that was holding the blood in his neck when they raced him to the hospital. And what is more important, public safety or your First Amendment right? They both are, it's equally important in my mind. But I don't want to sacrifice any lives. How do you feel about that?
I think that when you're balancing First Amendment rights with public safety, the courts have addressed that, and that comes up in the true threat doctrine. And I think in terms of clarification around this proposed language, I don't see this as imposing additional restrictions on law enforcement beyond what largely already exists within the fair and impartial policing policy.
I think that if we need something and it has to come out of the legislative body ultimately, that it could in fact be that. Because there are certain levels of politics and activism involved. And it can't be that way when you're looking at public safety. That's me.
If it's all right to just clarify.
Yes.
When I said that, the goal of this is not primarily addressed at law enforcement, I think where this would change current law and change the fair and impartial policing policy is this would be more broadly applicable to other agencies within the state government. Since right now, law enforcement is primarily the entities that have existing regulations. This would expand this within other areas of state government, which is largely our concern here. So I think just the purpose behind this is not to put more restrictions on law enforcement than already exist, because we have done a lot of that work already. I think the larger concern is other areas within state government.
I think it needs to look more specifically than at what you're looking to do, because right now it looks a lot like a law enforcement issue.
Which one, Tom?
Well, just the interacting. I was just reading the federal law, 8 U.S.C. and entering contracts and helping with. Who is it going to be? We're going to do that with. We're going to do that with ICE, Border Patrol. What about DEA? What about ATF? They take care of us. Nobody complains if I go give the DEA some information on something.
So, but I mean, folks, is that the language that we got, or is it the language that Falco's proposed?
I'm not sure about one topic. I just think the whole thing is dangerous.
Right. That's all I'm trying to understand on that. And we'll definitely have law enforcement in. We have. We'll get to Chris Brickle. We'll probably reschedule him because probably folks need to get prepared for the floor. So yeah, we're definitely gonna have law enforcement in to talk about this as well, Tom. And we need to, if we're gonna consider this additional language, we need it in front of us before. There's been some confusion of what, because that part seems fairly separate as far as these First Amendment rights versus what we have here. So we will reschedule that to have a chance to look at that language when so we can take a look after having read it. So we will adjourn until tomorrow, sometime after the floor.